So good morning. I'm sorry I'm missing once again, um, but we need to continue on. So what I would like for you to do is to go to Moodle, make sure that you complete the February 12th assignment. I see 3 of you have turned it in, and the rest need to get it if you have not uh, uploaded it, you need to upload. If you have not finished, you need to get it finished and turned in as soon as you can. All right, so we're going to focus in today on appeals court. Actually, here's the targets we're going to be working on. We're going to identify Ohio and federal court structure. We're going to explain how the federal courts and Ohio courts are similar and different. And we're going to gather evidence from landmark Supreme Court case regarding a case that changed American society. So let's move forward. I'm going to start off with appeals court. And although I know at least one class has already gone over this, I'm going to start here and go over it again. An appeals court can only set aside a conviction for one of the following 3 reasons. Now, just a reminder, you have a trial that takes place in a trial court. That would be generally a local court. Then if the verdict is seen as, for whatever reasons, unacceptable, the defense and in the prosecution can appeal the case. There can only appeal the case to the appeals court for one of 3 reasons that you see here. The verdict was unreasonable or couldn't be supported by evidence. The judge made an error in law, and we've already talked about an error in law. It's a mistake. It's somehow something was permitted to happen in a court, or the judge actually made an error in his statements to the jury. And so it can come in a lot of different forms. And then finally, 3, there was a miscarriage of justice on any grounds. If you remember on the movie Reuben Hurricane Carter, there was certainly a miscarriage of justice when much of the evidence was not presented. All right, so let's move forward. We're talking about appeals case. We're going back to this idea of error of law, which is a mistake as to law applied or applicable to the case. If minor trial court decision, it will not be reversed. So if it's just a minor thing, nothing of any significance, nothing that would have made any difference to the trial anyways, there would be no acceptance of an appeal. All right, then precedent, and of course error of law and precedent are 2 words that should have been in your word knowledge. All right, this is when an appeal court decides a case. It's a written opinion and it's issued, and this opinion sets a precedent for similar cases in the future. Generally, these are for the area within that court. It doesn't necessarily mean across the United States. Okay, lower courts in the area where the decision was made must follow this precedent, as it says. Higher court has the power to reverse or change precedent. So that higher court that appeals can make a change. As we see, the Supreme Court does this on a pretty regular basis if a case has been appealed to them. All right, now the courts in other parts of the country, again, are not required to follow precedent. Okay, moving on. So in addition, appeals court. An appeals court is where one party presents arguments asking the court to review a decision of the trial court. The other party presents arguments supporting the decision of the trial. So what we're talking about here is what actually happens in an appeals court. Unlike in a trials court, where there are juries and witnesses called, and we even went through the actual court process, appeals court is completely different. There's no juries or witnesses and no new evidence is presented. The only thing the lawyers, only the lawyers appear before the judge to make legal arguments. They have a specific period of time in which they have to make this argument, and then they have an opportunity to be questioned by the justices. And then once that's done, they leave, and then the appeals court judges will then deliberate. They may take a little while before they make their decision. They do not answer the question or have a finding when the lawyers appear before them. It takes them a while to make a decision. The Supreme Court, when they're asked to make a decision, sometimes it takes months before they actually make a decision. Okay, so moving forward. So once an appeals court makes their decision, they can do a written opinion. Now, most judges in an appeals court, well, you can have as many as 12 and as few as 3 judges in appeal court. In a state court, and we're going to see some pictures of that here in just a bit. State court does not necessarily mean 12. Supreme Court, I'm sorry, I said 12, I meant 9. The Supreme Court has 9 justices. The state court doesn't necessarily have that many. But the process here in making a decision is the same, whether it's the Supreme Court or a state's appeal court or a federal appeals court. First of all, the majority opinion is the decision, and it states what the court has decided and usually gives the reasons for it. Now, all the justices may agree with the majority opinion, or some may not, especially if it was not a unanimous decision. Then the justices who did not agree with the decision have the opportunity to write a separate opinion. And so they write that, and it states the reasons for their disagreement or dissent. This is extremely important because this may set up in the future a possible change in a law. So, that is not necessarily unusual. For an example, Jim Crow laws were held by the Supreme Court for years until finally the judges changed their mind. They used a lot of the dissenting opinions that had been set before and then rewrote for the abolishing of the Jim Crow laws. All right, then the last opinion that can be written is known as a concurring opinion, which is judges who agree with the majority opinion, but for different reasons. They may write a concurring opinion. All right, so you could literally have all 3 of these written on just one opinion. Okay, moving on. So let's look at the Ohio State federal and court structure. All right, I'm going to open this up for you. And let's look at this. Alrighty. So here's how this works. We have, and let's start at the bottom over here with the trial courts. There are 88, in Ohio, there are 88 common pleas courts. Those are county courts and municipal courts. Okay, and those are our trial courts. Now, if for any reason this opinion that's been set by this particular judge is disagreed upon by, the actual defendant or even the prosecutor, they can appeal to the Ohio District Court. There are 12 in Ohio, and you can appeal to those. We have one in Dayton, and once you appeal to that, you can, that they have a choice whether they accept the appeal or not. If they do, then they'll hear the case. If they don't, then it's done. You're over with. But if they do hear the case and make a decision, and if it's still not acceptable for whatever reason, then you can still appeal and from the Ohio Supreme Court. Again, the Ohio Supreme Court has a choice whether they will listen to it or not. And if they do, then their decision could be final. But you could still appeal all the way to the Supreme Court. And we'll have to talk a little bit. You can only appeal certain things to the Supreme Court. And we'll look at that a little later. All right. Now, this was starting local in Ohio. Now, if you're starting in with a federal case, you begin with 94 trial courts all over the United States. We were going to go to see in Dayton the U.S. District Court in Dayton. Okay, so that's our field trip. We're going to go there. Now, if it's appealed, again, you can appeal from the district court. You can appeal to the U.S. Circuit Court, which is an appeals court. There are 13 in the United States. And then, so you can see at 11 regionals, and plus the one in D.C., District of Columbia. And then, in addition, a U.S. Court of Appeals for the Federal Circuit. So you've got a total of 13 there. Now, again, if the circuit court makes a decision and you don't like it, you can appeal. Again, the Supreme Court has a choice whether it will hear your case or not. The Supreme Court gets thousands of requests for them to hear people's cases or groups' cases. They only accept about 100 to 150 each year. So most people are completely unsuccessful in going all the way to the Supreme Court. And you have to have merit, there has to be a reason. And again, we go back to this one, just as a reminder, there has to be these reasons. If these don't exist, you won't get to an appeals court. It won't happen. All right, so moving on. So the court system, states courts have broad jurisdiction, hearing cases that deal with state law as well as many areas of federal law. Federal courts have limited jurisdiction, hearing cases, criminal, civil cases involving federal law. Okay, so states can have, there are some situations, federal law, which states can hear a case. Federal law, but there is some limited jurisdiction for federal courts. And then, again, the federal trial courts, as we saw in the picture, those are known as U.S. District Courts. All right, moving on. Oops, let's go here. Here we go. All right, so state and federal courts. Most state courts resemble the federal courts in structure and procedure. All states have trial courts. And I'm going to show you just a quick, this is the website that is for Preble County. And you can see the new, here is the new Common Pleas Court judge. This is Stephen Bruns. And just for your information, this is a Trail graduate. He's from this area. Okay. So, and this is Chris Washington, and he is the, I should do this. No. He is the clerk of courts. He kind of runs the courts. Judge does not, he runs the day-to-day stuff. Judge does not necessarily do that. But here is several different things that you can look at. Court records online. You can search for a specific court and court of appeals. You can print out case histories. You can even scan documents. This is great for people who are trying to find records for themselves. Okay. You can look at the calendar, court calendar, to see what's going on in the court calendar. So all of this is possible. Okay. Let me take this back. All right. Now we've already gone through this, and I'm gonna just for the sake of it, just to make sure we're clear. State courts have broad jurisdiction. Local courts, which is commentary, again, trial court, family domestic relations, civil, criminal, civil, bankruptcy. Juvenile court is not a jury. There's no jury involved in juvenile court, and that includes traffic, delinquency, dependent and neglected children, child abuse, child support, truancy. And yeah, I do. I was going to say I'm missing delinquency, but right there it is. Okay, and then there's also probate court, wills, administrative estates, guardianships, marriage licenses, and so on. We've got municipal court, and why is that not showing up? There we go. Should be. Okay. This is can be criminal misdemeanors, preliminary hearings and felony cases, determine probable cause, small claims, and adult traffic. All of those are part of Preble County courts. Okay, trial court, here's the majority of all cases. These decisions are usually final. However, if you lose a case in trial court, and if there is an error, you may appeal. And here is some statistics for you. You don't necessarily need to write this down. This is just for your information. So overall, federal courts handle about a million cases per year, but the state court cases handle about 30 million. So that just gives you an indication of the differences. About 1,700 federal court judges and about 30,000 state court judges. These decide most cases. All right. Okay. So here's some picture. This happens to be just a picture of a court, just to let you kind of see. I couldn't tell you what, this is just a picture I got off of Google, but you can see right here, this is an appeals court situation. This is not the Supreme Court. You can see there's only 7 justices here. But what you see here, these guys over here are the clerks. They're taking care of all the paperwork. This is an attorneys. They are appealing. There are no witnesses to this in this case. They're just discussing the case, why it should be appealed, why it should be decided the way it should, what they feel that it should decide. So here's one side, here's the other side. Again, I got this off of Google, so I don't know which is the prosecution and which is the defense. I have no idea. Okay, so moving on. This is the Ohio Supreme Court. So you can see, again, 7 justices. The Chief Justice is Maureen O'Connor, and then we've got 6 justices here. You can see a couple of them are fairly new. Mary DeGeneres is, I believe, new, but the rest, I think, have been there a while. Yeah. Okay. Now, again, it is limited to the kinds of cases listed in court case. This is the only part you need to be concerned about. This is just for your information. Okay, so district courts. There are 94 or trial courts called district courts, and they resolve disputes, determining facts, and applying legal principles to decide who is right. Okay. Trial courts include the district judge who tries the case and a jury that decides the case. Magistrate judges assist district judges in preparing cases for trial. They may also conduct the trials in misdemeanor cases. Okay, so this is what we're seeing. This is where we're going on March 1st. We're seeing this district court judge. We're going to probably talk to a magistrate. I don't know if we'll get an opportunity to talk to one of the actual judges. But the magistrate judges, they can assist in preparing for trials. They can also conduct misdemeanor trials. Now, this is just some additional information for you, and you can read through that. Okay. Okay, usually federal courts only hear cases involving the Constitution, laws passed by Congress, cases in which the United States is party, cases involving foreign diplomats, and some special kinds of cases such as incidents at sea, bankruptcy, and any incident on a military base. Now, this is important for our district court because of, and this is what we saw last year in some of the cases, was information and incidences that occurred on Wright Pat. So this plays a big role because of this military base that's right there in Dayton. And it's such an important, Wright-Patterson is a pretty big deal when it comes to military bases in general. So any case there is pretty big. Federal courts also hear cases that are based on state laws but involve parties from different states. That has to do with the 11th Amendment. We'll look at that. We looked at that last year. Hopefully you remember. Most federal cases involved are civil cases such as equal employment opportunity claims, claims under benefits of federal programs. Okay, and this is often civil cases, involve money. Federal criminal law deal with robbing banks, those whose deposits are insured by the federal agency, importing drugs illegally into the country, or using the U.S. mail to swindle consumers. All right. President appoints federal appellate and district court judges with the approval of the Senate. Bankruptcy and magistrate judges are appointed by the district court judge to serve for a limited term. Okay. Let's move on. Now, here are the judges that we may see. Actually, we will most likely see Magistrate Judge Michael Newman. He seems to be, in the last couple of years, have been the guy that we tend to talk to as a group. But Judge Walter H. Rice, he's been there quite a while. Judge Thomas M. Rose. These are all the district court judges. And then the three here are the magistrate judges. So they have been appointed by these two guys to serve. Okay? We have met her. I don't remember. I think we've met him too. And we have met him. I do not remember ever meeting Judge Rose. Now, I could be wrong. But so we've met them. So this is part of what we're going to be seeing, I hope, on March 1st. All right, so this is just a graphic to kind of let you know where we're working from. We are part of District 6, and you can see that includes Michigan, Ohio, Kentucky, and Tennessee. And then we are the Southern District of Ohio. That's us right here. Okay? This is where we are. Okay. Now, the U.S. Circuit Court has 94 districts. They're organized into 12 regional circuits, each of which has the United States Court of Appeals. A Court of Appeals here appeals from district courts located within its circuit, as well as appeals from decisions of federal administrative agencies. In addition, the Court of Appeals for the Federal Circuit has nationwide jurisdiction to help, or to hear, appeals in specialized cases such as involving patent law, cases decided by the Court of International Trade and the Court of Federal Claims. These are cases that most likely will not ever affect you, because unless you become involved in international trade or a patent dispute, which could happen, and so these cases are not as many as, say, a trial, so a local state trial court. Okay, so judges hear oral arguments by lawyers in formal courtroom session. Many cases are decided on the basis of the briefs and records alone, without oral arguments, meaning nobody says anything. So if an oral argument is permitted, the lawyers are given a limited time to explain their case to the judges, and then frequently the judge will ask questions about their case. All right, U.S. Circuit Courts, number 9, 10, 8, 7. Again, we're 6, 5, 4. Oh, there's 11. Sorry, I didn't jump in on 11. 4, 3, 2, 1. Okay, so all of these are, these often are where issues that are sent to the Supreme Court, they grow out of specific areas here. So this is often what you'll hear, like, okay, from U.S. District 9 or U.S. District 6, depending. Okay. Then we're looking at the Supreme Court. It's the final judge in all cases involving laws of Congress and the highest laws of all, Constitution. The Supreme Court, however, is far from all-powerful. Its power is limited by the other two branches. Remember, that is all about separation of powers, checks and balances, so on. All right, so how do you become a judge? They are nominated by the president and confirmed with the advice and consent of the Senate. So, and we just went through one with the Justice Kavanaugh, who was approved, and justices have life tenure, serving during good behavior. In other words, it only terminates upon death, resignation, retirement, or conviction on impeachment. Okay, so big deal. And here is the current court. Brett Kavanaugh is the newest gentleman to be added, and you can see Right now, Ruth Bader Ginsburg is probably the most elderly, with Stephen Breyer probably close behind. Neil Gorsuch in there, Clarence Thomas, Sonia Sotomayor, Elena Kagan, and Samuel Alito are the Associate Justices. The Chief Justice is John Roberts. Okay, they are nominated as again. They have a term of life, and society's most controversial issues are decided here. And here's some examples of what those are. This is a picture of the U.S. Supreme Court. Here's where the justices would sit. You can see there are 9 chairs. Here's where the attorneys, if they are allowed to present their arguments, one side is the prosecutor or plaintiff, the other side is the defendant. And these are the attorneys. These are not the actual defendant. They are not part of this. That you can go and watch these proceedings. That is possible. But they also have closed proceedings too. But you can. Now, what you see here would be additional people. The gallery people who would watch would be back further from this picture. All right. Most important legal precedents are established here. 9 justices hear each case, and a majority rules. If the Supreme Court decides to hear a case, writ of certiorari is sent. A writ of certiorari is a request of a lower court to send up its records. And we are going to watch this film called Gideon versus Wainwright. Not today, though. This is a good picture of what happens when something like this is appealed to the Supreme Court. All right. So each party of the case writes a brief, and then they are permitted to do an oral argument. And this is said, each side has 30 minutes, and it's open to the public. During the months of May and June, the court meets at 10 a.m. every Monday to release opinions. In other words, May and June, they'll hear cases throughout the year, but May and June are when you will hear their opinions. So we'll be coming up on some opinions here relatively soon. And I'm going to stop there. All right. That finishes up Chapter 5 notes. Okay? All right. So get those uploaded ASAP. Thank you. Hopefully I will be back on Thursday. Bye.